Hi, good evening. Today is November 14th, 2025, and it is 11:17 p.m. U.S. Central Time. My name is Rinaldo J. Aguiar Marcano, and I'm recording this video from my home located at the 2302 Britton Ridge Drive, Katy, Texas 77494. And I need to give more context about this address. It's a home located in front of the house of a gentleman by the name of Joel Grade, who is the chief financial officer of Baxter International. And both our homes are located 300 feet away on that direction from the house of Robert Mueller, who was the director of the FBI for several years ago. And both facts are very relevant to this conversation. So today, um, this evening, um, I have prepared. Basically, it's like a work session. It's more than a demo, right? So the idea is I have a list of things that I want to go over, and they've been accumulating. So I want to deliver them um, in a single comprehensive session. But I'm going to split it into two parts. One that is going to be focused on the legal aspects, on the lawfare that the network is waging against me. And the second is technical, right? Technical topics. So I'm going to split them so I can process them in the pipelines with different weights, because otherwise it creates noise. So, um, so that's the game plan. So because it's a lot of material, right? So I estimate this probably is going to take 2.5 hours, more or less, among the two sessions. I'll try to go through the observations as fast as I can, right? But so to really show you the things, I would like to debug as I'm doing the demo. And I didn't pre-debug everything, and so what I'm trying to say is it's going to be a bit bumpy. So bear with me, please, during this process. I think it's going to be a valuable session. So let's get started. So on the first part is going to be the legal part of the session, right? So let's start with that. And I have kind of a list of talking points that I put in a calendar invite. That calendar invite is on today's date on my Google Calendar that is tied to the call mobile b6@gmail.com account. So I'm mentioning that in case authorities have a way to see the notes in the calendar invite. There's a lot of information in there. So let me open my list of things. Okay, so I'm gonna jump right into it. Okay, so on the legal front, the latest, so on the family case, right, on the lower court area, the latest status was that Troy Pickett filed a fraudulent document Troy Pickett, in reality was filed by the cubic scapegoat, right? Like Rosemary Becerra. And let me back up for a second. Okay, so let me tell you what I'm going with all this. The pipeline infers that all this situation that it's unfolding caused by a combination of Morgan Heibner, Troy Pickett, and this quadratic or cubic scapegoat, whose name is Rosemary Wolf Becerra, could amount to a total of 5 counts of wire fraud. And this is relevant because, depending on, what happens, I imagine, right, when a prosecutor takes this, like whether all the counts succeed or not, but it could lead to different lengths of potential sentences, right? So the pipelining first, it could be up to 5 counts. So, I don't want to litigate the case here, but I would like to start by mentioning why or which could be these 5 counts. Okay, so but to give you that context, I need to tell you why this is war fraud, right? And this is mentioned in the demo before. So what the sequence was, this cubic scapegoat, Rosemary Becerra, filed on December 2nd on behalf of Morgan Heibner a proposed order, which was a draft coming from the Adams law firm. I imagine that they're going to say that she's a paralegal or something, right? So she filed that document, and that document had a series of fabricated orders that the judge never rendered. Orders for financial matters, ordering me to pay rent for the petitioner, giving control of the black Tesla to the petitioner, a series of things that were not mentioned in the September 11th verbal rendering of the judge. They were fabrications, okay? But crucially, this document was it was a draft, okay, filed on October 2nd. On October 15, on the evening at 8:17 p.m., I filed a second verified motion to recuse, which triggers automatic stay on the case. So, and we had a hearing for the 16th for the next morning, in which the judge was supposed to allow me to be heard in regards to my objections to the multiple fraudulent drafts that Morgan Heibner proposed, right? All of them containing fabrications of this kind, different versions of the fabrications, but all of them were the same, right? A series of fabricated orders that the judge never verbally rendered. And one crucial one was they changed the duration of the orders from 60 days, which is what the judge said verbally, to indefinite. They changed it, and they said that the orders were going to be in place until the divorce is final, which could be 2-3 years, like for how long they want to drag it, right? So that is a fundamental change, right? Stripping my parental rights indefinitely because it's a coercive weapon, right? What they're creating with that order. So anyhow, I objected to that. The judge promised that I would be heard on the 16th. But because I saw where this was going, I filed the second motion to recuse because of all the irregularities and all the procedural abuses and the court inaction, and there's a bunch of reasons, right? And this document is available online on the court on the case docket. So I filed the second motion to recuse on the evening of October 15th, which triggers automatic stay. It was 8:17 p.m. At that point, the judge hadn't signed anything because we were going to have that hearing on the 16th, right? And Morgan Heibner, in that day earlier at 11 a.m., had filed an exhibits list for the hearing on the 16th. And on the 16th, when she showed up to court, she said that she was there to discuss the drafts. So she admitted on the record that the orders were not signed. But in a miraculous turns of events, Pickett, on November 7, 2025, filed a document with the court saying that the orders were signed on October 15, implying, like what he's saying, is that they were signed before the motion to recuse, because he knows that after the motion to recuse, it's impossible to sign them. The court doesn't have jurisdiction, right? But there's a series of irregularities with that document, right? The first one is the index number. It got index 89, the supposed orders that were supposedly signed, but the motion to recuse got index 88 in the docket. So that shows that they were signed. If they were signed after the motion to recuse, which makes them invalid. That are in this document are the ones for the draft that was filed on the 2nd. which shows that it wasn't served to me on the 15th. They couldn't serve it because I filed the motion to recuse. And if they serve it to me, it will show the timestamp, and it will clearly show that it was signed after and served after the motion to recuse. So that's why they couldn't serve it to me, right? But anyhow, all these things show that the document is fraudulent. But the most damning evidence is that Troy Pickett is in knowledge of two contradictory facts about the supposed date of signing of these orders. One, because he was the same attorney, this same Troy Pickett was the attorney on the appellate court case, on the first appellate court, in which the case got dismissed because the orders supposedly were signed before the 14th. So the first appellate court emitted an opinion on the 14th saying that they couldn't do anything about my petition because the orders were already signed. And Pickett was the lead attorney, was attorney on that case, right? So he knows that according to what he represented to the first appellate court, that the orders were signed before the 14th. But on November 7th, he filed a document and signed it saying that the orders were signed on the 15th. And the orders cannot be signed both before the 14th and on the 15th. Those are two contradictory facts that he's presenting to two different courts. So he knows this proves, this filing of him proves that he knows that fraud was committed in one or the two courts or in both. And in either case, he's making monetary demands and a series of demands in this document to me on a fraudulent premise designed to deceive me and to deceive the courts, to deprive me from a series of things. And those things are the different counts of wire fraud. And it is wire fraud because he used the electronic system of the court to serve me with that fraudulent document to defraud me and to deprive me from money and property. So it's what I think what people call in that industry, in the legal profession, right, a kill shot. Like, it's an argument that it's inescapable. Like, he signed that document, right? He confessed and filed the confession with the court. So that's the status on the family court. Okay. Now, of course, I filed. Well, and then what happened, right? The orders expired because we're waiting for the motion to recuse to be ruled on by the administrative judge of the 11th Administrative Judicial District, I think it's called. And November 10th, 2025 arrived, and that's the date in which the verbal orders that the judge rendered on September 11th expired. So the situation is that the child is unprotected and there's no orders of any kind, standard or temporary or anything, governing the situation. And the child is, of course, endangered because of this lack of protection. And Troy Pickett, in his last filing of November 7th, this is not his last filing, then he made another one, but on that filing, he's saying that those fraudulent document are like that are the orders. Like, that's his statement. So it's a situation of complete breakdown of the judiciary system, caused by Troy Pickett and Morgan Heibner in cahoots. Okay. As a side note, Troy Pickett also canceled an agreement created by the Adams law firm, an electronic agreement, to withdraw Morgan Heibner from the case. But the fact that he canceled the agreement that was created really by the Adams law firm shows that he controls the Adams law firm. So that takes it to a level which is not really, it's not like they're working in cahoots. It's that Troy Pickett controls the Adams law firm. So that is conspiracy, right? Conspiracy to defraud. So that's the situation, right? So of course, because of that situation that the orders expire, well, first of all, I filed a document called the fourth supplement to my motion to recuse, in which I explained the fraud, right? And I attached the the way they deceive the appellate court, because that shows that he has two contradictory dates that he's given to two different courts, right? And I also attached the fraudulent orders that he's saying are the orders that are signed, right? To make all these series of demands, to deprive me from property and money. So I filed that for supplement, and I also filed, after the orders expired on November 10th, I immediately filed the same day a motion to strike. A motion to strike that fraudulent document that he filed saying that those were the orders signed on October 15th. And I gave all the reasons why it should be struck, right? Yeah, we're waiting for that, right? But the reason I'm bringing this up is because when I did that, he filed, his response was to file a motion for sanctions against me. So he's asking the 387th court to sanction me because I'm filing too many documents. That's the argument, right? Excessive filing. And because I'm creating unnecessary delays. But this is very interesting. I mean, the choice, right? The choice of, and you can see, like, I mean, this is interesting in too many dimensions, right? And I don't want to make it overly complicated, but I think it's something that we should really spend some time understanding, right? The choice of the path that they choose for that response. See, he's not responding to what I'm saying. I mean, I'm saying in a filing, in a legal filing, that he committed wire fraud. That's what I'm saying. I mean, I'm not spelling it out. I'm not saying, USC 1343, I think is the statute. I can't recall the number, but I'm not spelling it out. But what I'm saying, right? I'm describing what he did, and I think if I can see it, any lawyer that reads that should be able to say, immediately, this is wire fraud, right? So I'm saying that in a legal filing, and I filed it with the court, right? And his response is not to argue that. His response is to hide on the procedural side of things. You see what he's doing, right? So first of all, he's attacking me, right? He's asking for sanctions, which is, there's 4 motions of sanctions pending against the Adams law firm that haven't ruled on for months, right? It would be hypocritical that the 387 imposes sanctions on me before ruling on the 4 that are pending against Morgenheimer and the Adams law firm. But beyond that, right, he did not respond to the allegation. Like, I'm saying something that is very serious, that he's committing multiple federal crimes, and he's not addressing that issue, right? And I don't mean to, I try to keep the conversations high level, right? But when I see this, and I apologize in advance for what I'm going to say, right? But when I see this sequence, the first thought that comes to my mind is, Troy, grow a pair. Like, if you're going to do the thing, you have to go all the way, right? You have to say that you didn't do it. But the reason why he can't say that, because he would add another count. It would be furthering the scheme. Like, if he defends the filing that he did before, saying on November 7th, if he defends that, if he says that is the order, again, that would be another count, right? So that's why he doesn't do it, because he's afraid of the federal prosecutor, right? So what he does, he has to say something, right? Because if he doesn't say anything, he's conceding, right? So what's the solution that they found? To ask for sanctions based on that I'm adding delays. I mean, this is ridiculous, right? I'm saying that you're committing wire fraud, and your response is to say that I'm adding delays, right? So I don't know. I think Troy should grow a pair, really. But it is what it is. Now, I have to say, I think Troy should approach the authorities, right? Before I file a report to the FBI, to get ahead of the issue, right? I mean, I imagine, right, that he must have family and kids as well. I really don't want him to be separated from his family. So I think the best course of action for Troy is to approach the authorities proactively before I get there, right? But I don't know. That's just my thinking, right? So yeah, so his response was, I mean, I wrote it in the calendar invite shy, but it's not really shy. It's he's afraid of adding another count because it could be another 20 years, right? And there's already 5 counts. So let me tell you about the counts, right? And this is coming from the pipeline, like maybe some of these things may not qualify as a count. I don't know, right? But from the technology that I have, it looks this way, right? So the monetary demands are 1, because he made explicit monetary demands based on this fraudulent document, and he used electronic means to do it. And he knows the document is fraudulent because of what I mentioned before, right? That he gave 2 contradictory dates to 2 different courts about the same document, right? And he was the attorney of record in both cases, so he can't say that he didn't know. The second one is the Tesla, because they removed the Tesla from my Tesla account using fraudulent means as well. And that's electronic. It's electronic fraud, right? I mean, and both because they use electronic communications to send the TRO, whatever is that missing in the index number 7, right, to Tesla. Or even if it was the index number 8, they never serve it with the document, and it's also fraudulent. And they send that to Tesla through interstate wires, allegedly, right? And then they use that. They did that to remove to deprive me from the possession and access to the vehicle, which is my property. Right? So that's the second count. The third count is the child passport. In the same fraudulent orders, they're ordering me with this fraudulent order to give my son's passport to Morgan Heibner. Imagine that. To give possession of the child passport to Morgan Heibner. And the child passport is property, right? It's tangible property. It's a physical object that, although it doesn't have a monetary value, it doesn't mean that it doesn't have value. It has an immense value because it gives permission for the other parent to travel with the child without even asking for my permission internationally, right? So that is the third count. The fourth count is something that happened. I mean, and the score is borderline, right? Because there's many things that I see in the debug output that come into play that I cannot see how it would go, right? But I have to tell you also, this thing that I want to tell you was produced by the pipeline using information that I obtained from the Venezuelan informant. And this is unverified information, right? So if any people that work in the, I don't know, authorities, right? See this video, you need to, I would say, right, investigate this because I have no way to verify if this is just a tip, right? But if it is true, it would be another count. It could be, right? Now, I don't know if this would be probable cause for you to investigate, right? But I'm going to say what I heard from the informant. He said that in 2021, my former partner, when she asked the court, so she asked this 505 court, which is the court where David Perwin was a judge before, right? So that's in court. She asked that court to modify her divorce decree to Salvador Mendez, which the pipeline tags as really Andres Salvador Mendez. The reason for the modification was that to allow her to obtain a passport for the other child, for the child that she had with Salvador Mendez, right? In 2008, which is my stepson. So she wanted permission to get the passport, right? The informant told me that petition of modification was really prepared by the Adams law firm. but she appeared pro se. Okay. If you read the docket, it says that she appeared pro se. But the informant told me that that was really produced, that those documents that she used to modify the divorce decree and subsequently get a passport for the other child. That was prepared by the by the Adams law firm. He didn't say specifically Morgan Heiner, but he said the Adams law firm. Now, let me tell you why this could be another count. It's because they claim, there's multiple reasons, right? So they claim that Salvador Mendez was crazy and living in Venezuela, right? That's what they claim. They claim that in the divorce, and they've said that multiple times in multiple filings, right? But yet, if you read the docket of that in that modification, it says that both parties appear pro se via Zoom, which is good because it could allow the authorities to see the face of the Salvador Mendez. Like, I don't think they would have had that foresight in 2021 to hire an actor to do that, right? So probably the real Salvador or Andres Mendez appeared in that Zoom hearing. But beyond that, right, they allege that he is crazy, that he is a person with a severe mental illness that lives in Venezuela. So how is it possible that they ask this court, the 505, to modify something so serious as to modify the divorce agreement without asking a psychiatric evaluation, another psychiatric evaluation of Salvador Mendez? Because if he's not sane, he cannot consent to that, right? So it would be a court taking advantage of a pro se litigant that it's mentally incapable. If the court agreed to that without asking for a psychiatric evaluation of this person that, according to the same court records, is supposedly crazy, right? And also, in that docket, it says that notices were mailed to both parties. And this is a tremendous anomaly because he's supposedly crazy in Venezuela, where the postal system in Venezuela is, it doesn't have, it's not like Canada. You send a letter to Canada via USPS and it arrives in 10 days, right? If you send a letter to Venezuela, it might arrive if it arrives in 6 months. So how is that the Fort Bend County is mailing letters to Venezuela? So that suggests that maybe it was mailed to an address here in the US, which would be a misrepresentation to the court, right? Because they're representing that he's in Venezuela, and he's not in Venezuela, he's here, right? So in short, it would mean using fraudulent means to deceive. In this case, the victim of the deception would be the passport office, right? Or I don't know, UCIS, I don't know, the entity that controls or emits the passports, right? Because they're making them believe one situation that is not true, right? And also they're deceiving the court. So that could be the fourth count. Now, that thing, I mean, although it's not directly related to this case, it's important because it could show planning, right? I mean, that passport application and this whole thing with the modification of the divorce decree was on December 2021. If you think of that time frame, that was shortly, it was like 5 months after my son Marcelo was born. And it was around the time where the Cuban Safe House at Lara Creek Drive installed the power line communication modem underground that communicates point to point with Robert Mueller's house. So, I mean, I can't prove this, but what this hints at is that move of getting the passport, and at the same time, she applied for a passport for the other child. So the passport that Morgan Heibner and Troy Pickett are fraudulently trying to deprive me of the possession of, was obtained also on December 2021. So the inference or the possibility is that they obtained the network, right? Made all these moves to obtain the two passports of the two children. Why? Well, to put the petitioner in a position, to put my former partner in a position where she could take the two children internationally if they found themselves in a situation like the one they're in right now, right? So in a situation of panic or chaos, they could take the two children and make her leave the country, right? That would subdue me, right? That was the thinking, I think, right? Like if they kidnap the children and take him to Venezuela, I will have to, do whatever they want, right? So that's the inference, right? So that's how it connects that fourth count to the bigger picture, right? It's not a random thing that happened isolated, right? It's connected, right? It's related because it's part of the same plan, right? Or how to create a situation that would subdue me, right? If they needed to. Now, what's amazing to me is the level of foresight, right? And this, you can see here that these are state actors, right? Like the reason why they can foresee so far in the future is because they've been doing this for 70 years, right? To thousands of people. Because I'm saying this because in 2021, right, I did not have the geoindex. I did not have the technology to detect any of this. In the way I see it, I could not possibly have been a credible threat to them, right? A credible threat to them. Like, it's like making all these elaborate creating all these elaborate scenarios to fight with a mosquito, right? But the reason why they do it is because they're state actors, right? They have planning capabilities of a state, and they know that even if I was a mosquito in 2021, they foresaw that something like this could happen, right, in the future, because maybe something like this happened before. Right? So, but that's the fourth count. And the fifth count is Troy Pickett filing that document with the court, asking for sanctions and saying that, so if you read the document that he filed, he says that my filings and motions are dubious. That is the word that he used. He did not say that they were false. Like, he did not, and this is, for what I said before, right? Like, he doesn't want to add another count, right? He's avoiding that. He's avoiding to commit to the position of saying that what I'm saying is not true, right? But he's saying it's dubious, right? He's putting it in doubt, right? But he's not saying that it's false. But anyhow, I think, according to what I see in the pipeline, that could also be a count, because what he's doing, even if he's saying that it's dubious, right? What he's doing really is furthering the scheme, right? Like, if his motion is agreed on or ruled, positively by the judge, he would be furthering the scheme. So it's another count. Like, it's an action designed to do the same, to deprive me from the possession of the passport of the child, the possession of the Tesla, and from money, right? So it could be a fifth count. So those are the 5 counts. So I have to tell you, let me share my screen with you. Okay. So, I waited for a few days to see if he made more mistakes, but, he shut up. And I think he realized, right? So, today I went to the federal court and I filed this with the federal court as a notice of evidence, right? So now this is on the 2 cases. So I want to show you where to find that document in case something happens or whatever, right? You get the document. So in this bucket that I'm creating, where I'm putting all the court evidence, if you go to court evidence, Troy Pickett, and then this subfolder that says wire fraud, here's the statute, is 18 USC 1343. So I filed this document called 4_25-CV-02-276 index 24. So it got the index 24 assigned. And if you open it, you will see it has 113 pages, and you can see it was filed. This is the official stamp, right? You can see this is the case caption, like the case metadata that the court puts in the document. So you can see that this was filed. This is filed, and it's available on Pacer. So it's document 24, and it was filed on November 14, right? And it has 113 pages. And so here I explain what this is, right? The developments and the wire fraud and everything. And I attached two documents. Number one is the motion to strike, which is at this point pending for ruling by the administrative judge of the 11th Administrative Judiciary Circuit. And it has, the motion to strike that I filed with the 387 directed or addressed to the administrative judge, right? That is reviewing the motion to recuse. That was filed on October 15th, and today is November 14th. So it's been exactly a month. This motion has been pending for a month, and the child is unprotected. There are no orders right now regulating any of this, and the child is kidnapped. Like the petitioner is acting as there's an order, right? Of course, I'm not going to start fighting with her whether the order is valid or not, because if I go and retrieve the child from daycare, Troy Pickett is going to call the police, right? The Fort Bend County Police, right? So I'm not going to fall into that. But the judge has to address this, right? And so it has two exhibits, right? The first exhibit is the motion to strike, and the second exhibit is the fourth supplement to my motion to recuse, which explains the fraud in more detail, right? Like it explains the fraud with more granular detail than the motion to strike. So that's why I included both. And both have a copy of the fraudulent orders that Troy Pickett, is trying to pass as real orders. I'll try to find it for you. Right. So it's, let me see if I can find it. So it should be after the certificate of service, right? Yeah, this one. Yeah, so this is so on page 58, right, of this document, on the exhibit B is the fourth supplement to the motion to recuse, which details the fact that he is in knowledge of two contradictory facts that he cannot deny that he's in knowledge of, right? So he knows that fraud was committed, and still he's using that document, fraudulent document that he knows is a fraud, to make all these demands and deprive me from money and property. Money, the Tesla, and the child's passport. And in this particular exhibit B, then the exhibits of that exhibit, of that filing, that was originally done in the 387, has the opinion issued by the first appellate court, which is the court that he deceived with the fraudulent document of Morgan Heiner of October 10th, right? So, I mean, this contains all the evidence of this scheme, right, to defraud the two courts. So it's a self-contained document that has everything needed to convict Troy Pickett, with just one document, with just one filing, right? Because this is his own filing. Like he signed that and put his bar number in it, right? Like this is not an inference, it's not a guess. Like, this is something that he said in writing, right? So it's inescapable. So I just wanted to show you that document. Okay. Now, on another legal topic, the conference of November 20, 2025. So in this case, right, this case that I'm showing you, the 425. What is the number? Let me show you. Yeah, this case in which this is the class action, right, against Elon Musk and a bunch of other people. The case number is 425-CB-02276. So there was a conference scheduled for November 20 for next week, and it got postponed. And I got a letter saying that it was postponed because I haven't served the respondents. I mean, I'm not going to draw any conclusions from this, but I have to tell you, the reason why I haven't served them is because the time to serve them expired, and I filed a motion to the court, addressed to the court, asking for an extension, and that motion hasn't been ruled on. Right? So I'm waiting for the court to rule on the request for extension. I'm not going to serve anybody if the judge doesn't okay the extension. Right? He has to take a position on the request for extension. The grounds for my request or my motion for extension is that I've been under extreme duress because of the harassment and the kidnapping of my son. So that's the reason why I wasn't able to serve them in the 90 days that the rule says, right? And because I filed this lawsuit in May, right, months ago. So I'm waiting for the judge to rule on the motion for extension. Right? But the judge hasn't ruled on that, and his response, or the court, I don't know if it was the judge or it was the clerk, but the response of the court was that because I haven't served the defendants, the conference was postponed, right? And I was waiting for that conference to ask for the court to intervene because the state courts are not doing anything, right? We're just waiting, and the child is unprotected. So that's an interesting development that it was postponed. But on the bright side, I got that paper that says that they're waiting for me to serve the defendant. So I'm going to take that as my motion for extension was granted, right? That's an explicit acknowledgement that I can serve the defendant. So I'm going to go ahead and serve them. So that this is actually good, right? Because the court took a position on the question of whether I can serve them or not. Okay. Next legal topic. So I have automatic ingestion in many data sources, right? One of them being the bank accounts. One of the bank accounts is shared, or I'm authorized by the petitioner. It's shared with the petitioner, right? It's an HS account ending in 0720. The pipeline picks up that there was a deposit for $38,000 in that account, and it got that dollar amount, got co-clustered with the last known amount known by the pipeline for her retirement account. So this got flagged because and it got also co-clustered with that transcript in which there's a mention of the legal fees exceeding $60,000, which was the basis for me to file the TRO with the First Appellate Court, right? That ultimately made them pull the trigger on the rules, right? I mean, Morgan Heibner and Troy Pickett, right? So the inference of the pipeline is that this money is to justify keep paying for the attorneys, right? For the legal harassment campaign. But the pipeline, and like this, I have to say, I tweaked it a little bit. I mean, the parameters, right? The hyper tuning parameters, and maybe it got too aggressive. I don't know. I want to take the opportunity to ask the Venezuelan informant if you could please check with your lawyers to see if this is something I should do. But the pipeline flags that this money, if it goes to fund the attorney's fees, it would be a direct violation of their own order. The fraudulent order that Pickett says is the order. That order says that there's an injunction in which she cannot spend money in anything but necessary living expenses. And if you add 60,000 that she already said on the record, and Morgan Heibner, right, that they have spent in legal fees, plus 38,000, it would be $98,000 in legal fees for a parent that is unemployed, right? So that would be a direct violation of the injunctions of their own fraudulent order, right? So the pipeline, and this is why I say that maybe I made it too aggressive, right? Thinks that I should file for a temporary restraining order to preclude the petitioner to keep spending money on the lawyers. Because it's unreasonable for a parent who is unemployed to be spending $100,000 in legal fees to harass the other parent. And it goes against the injunctions that they're saying that are the orders, right? So, but I don't know. So please ask your. This is one of the things that I said the other day, right? Like the pipeline doesn't have moral compass, and maybe this is too aggressive. I don't know, right? But if it is something that I should pull the trigger on, I would do it. So throw me a bone, please. Please. Okay. Another item flagged by the pipeline. In that proposed order of October 2nd, that was filed by this cubic scapegoat, right? Cubic, why? Because she's going to be the scapegoat, or was going to be, right? If they were thinking that there will be no way to prove that Pickett is doing all this. This is the mastermind behind all this, right? Which is not really the case, because he canceled that agreement created by the Adams law firm. But she's called cubic because the chain of scapegoating was, Troy Pickett would say it was, the Adams law firm, right, that committed fraud. William Kyle Adams would say, so that's one level of scapegoating. Then William Kyle Adams would say it was Morgan Heibner that committed fraud, and she is his employee, and he was trusting that she would act professionally as a lawyer, right? And then Morgan Heibner would say that it was Rosemary Becerra who really filed the wrong document because she was grossly incompetent, right? And Rosemary Becerra would be the scapegoat for the three of them, right? So that's why it's cubic. But of course, this was just in an ideal world that they created in their minds, because this is not going to be the case, because it's demonstrated that Troy Pickett controls the Adams law firm, and he can cancel agreements that affect the client relationship and the income of the firm, right? He might as well be the managing partner, right, of the Adams law firm, because of the level of control that he exhibits, right? But anyhow, in that October 2nd document that ultimately ended being the instrument of the wire fraud that they're saying that are the orders supposedly signed on October 15 with no certificate of service valid, right? That document doesn't include the certificate of service. The certificate of service, and this is something localized to Texas, I'm going to give a bit of detail, right? So it's a statement that you are obligated, when you file a document in court, in Texas at least, you're obligated to put this statement after the signature block of whatever it is that you're doing, saying that saying under the penalty of perjury, that you serve this thing to the other party, and you have to say when. Let me give you an example. In this document that I filed with the federal court, right? This is my certificate of service, right? See, it's on page 4. It says, I hereby certify that on November 14, the original of this motion was hand-delivered to the clerk and will be served. I'm not saying that I've served it, because I haven't served it, because I haven't received authorization from the judge to serve anybody, right? Because of the extension, my motion for extension is pending, what I said before. So I said, this will be served to all consuls of record upon the court's ruling on the corrected motion for leave to amend complaint, dated blah, 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 and for extension of time for service. Right? I'm saying explicitly, and index 17, I'm saying explicitly, I haven't served them because you haven't given me the authorization to serve them. Right? So this is what a certificate of service looks like, right? And making a false statement in this is perjury, right? It's a crime. Now, in that October 2nd document, Morgan Heibner omitted the certificate of service. There's no certificate of service. But in all her other filings across the entire docket, every time she put the certificate of service. This is important because it shows premeditation, right? It shows that she knew that the document, she and Troy Pickett, right? They knew that the document was not going to really be served. Why? Because I had already filed the motion to recuse, and if they served it, there would be a timestamp, electronic timestamp, and I would say this was filed after the motion to recuse, therefore is void, right? So they couldn't serve it, and they knew they wouldn't serve it. So they intentionally omitted the certificate of service to avoid committing perjury, right? But it shows premeditation from Morgan Heibner, who is the attorney that signs the document. Right? Although it was filed by Becerra, this was signed by Morgan Heibner. So, in an ideal, in their ideal world where things wouldn't be discovered to this level, she could say, well, Becerra forgot to add that page, right? But I mean, at this point, it's clear that this document is fraudulent because of all the reasons that I was already said. And what a coincidence that they didn't, they did not serve it to me, right? And I showed in the previous demo my email. There's no, I never received any email about this document, right? The email I received when Troy Pickett stated in a filing that that document was the orders. That is the instrument of fraud, right? But the actual orders on October 15th that they say were signed and served, they weren't served, right? So it shows premeditation. Right? It shows that they did this with design and intention. So this is important because that's needed for the wire fraud charges. It's needed to show intent to defraud. And what I was saying is that they could claim that it was incompetence of this Becerra person, but what a coincidence that this incompetence aligned with the fraud, right, and allowed the fraud to happen, right? Like, not including that page conveniently, right, and because it would be perjury, right? So it shows intent to defraud, and it also shows premeditation on avoiding consequences of the fraud in their mind, right? Because they think that they're smarter than everybody else. So yeah, and of course, it also proves coordination with Pickett because ultimately, the person that perfected the wire fraud by filing that document saying that those were orders that were in place and making all these demands in those orders was Pickett, right? Who is shown to control the Adams law firm. So, that shows that it's a scheme between Morgan Heibner and Troy Pickett. Right? They are co-conspirators in that. Oh, this is another one. So on November 13, which was yesterday, so at this point it's past midnight, so it's really the 15th, so it was 2 days ago, right? But on the 13th, I got information from the informant that the network was planning to shift focus from the lower state court to the IRS, right? So to weaponize the IRS again, right? The enforcement department, which is, they haven't learned the lesson, right? It's not a good idea to harass with legal action, even if it's coming from the IRS, a person that has the database of all your financial crimes, because I'm going to turn that around against them, right? So, for example, I will explain to the IRS, when they send me that letter, I'm going to explain why I have been under extreme duress for the last 8 months because they kidnapped my son, and that this is coming from Robert Mueller because I have a recording of the Tesla transmitting signals to Joel Gray. Right? And I'm, of course, going to mention the 50 reports, Form 211, that I already sent to the IRS for the last year, and they haven't processed any of them. Right? They dismiss them procedurally, right, with the gatekeeper algorithm, right? But they're just going to open a door that they're not going to be able to close. So let's see what they do. Another thing, and this is mentioned in one of the mobile demos, right, that I'm doing, that I'm posting on the channel. In one of the instances that I went to the court, to the federal court, I parked. Let me show you. Let me show you where this was, because maybe that car has GPS. So if you go to Google Maps and you look for the Southern District of Texas, I think it's 515 Rusk Street. Right. So this is the building of the federal court, right? The courthouse. And then there is this it's kind of a bridge, right? It's small, it's very small. I usually park the car in this street. And there is a meter here, right? So there was an instance, I think it was around October 21st, but I'm not sure. I have to check the system, in which I was driving the SUV, right? The Tahoe, the Suburban, sorry. And behind when I come back, behind the car, there is a Toyota Camry, gray, that has a license plate of the Department of Justice. But what's interesting is that when I turn on the system, it got flagged for multiple reasons. But one of the strong reasons that is very visible is that it has mounted behind the rear view mirror one of these advanced espionage machines that the Chinese are deploying on vehicles in the US, right? For Diosdado Cabello and for the FSB. So how did they get that device in an official vehicle of the DOJ? Well, to be honest, I don't know what the rules are of issuance of that plate. It could be that is really a personal car, and the person, because they work in the DOJ, they can obtain that plate. I don't know, right? Or if the car is owned by the DOJ, right? My intuition, I mean, if I see a car with an official plate, I would imagine it would be owned by that dependency, right? Like if you see a car with a diplomatic plate from the, I don't know, let's put any country, right? I don't know, Argentinian embassy, right? You would assume that the car is owned by Argentina, right? Not that it's a car owned by a person on the personal name. But I don't know, right? I don't know the rules of this. Maybe a person that works in the DOJ can obtain this plate and put it on their personal vehicle. I don't know. But it was concerning to see that there was this car with an official plate of the DOJ and this espionage device produced by the Chinese, right, instead. So I don't know. And this is in the recordings, right, that I'm posting. So, it should be easy to check, right? Yeah. So that's that. So I think with this, I'm going to close the legal topics. In short, the situation is we are waiting for the administrative judge of the 11th Administrative Judiciary District to rule on the motion to recuse and the request to assign a visiting judge, because obviously with this level of corruption and manipulation and fraud with the 387 court, it is impossible to get access to justice if it's not a visiting judge, right? So I think that's the most important part of that request, right? Because we do nothing if they recuse the judge, but then they bring in a different judge that it's another David Perwin, right? It cannot be a judge appointed by Abbott, in short, right? I think be the logical thing to do, right? Because at this point it's obvious that there's a pattern, right? Anyhow, I'm gonna close this session, and I'm gonna move on to the technical topics, which is a very exciting session that I have prepared. I'm gonna take a 5-minute break, and then I'll be back. Okay. Thank you so much, and see you on the other session.